Tom Maliti and Kwamchetsi Makokha. Good morning, gentlemen.
Good morning.
It's good to have you both on air. Tom, we spoke with you a couple of weeks back, and we're basically just having the same conversation, the unfinished business with the ICC that Kenya has. Now, here is some swanking brand new development. What do you make of this so far?
I am as surprised as anybody else that a lawyer, Paul Gisheru, in essence, showed up in the Netherlands and said, "I hear you've been looking for me. Here I am." And just to clarify a few things that have been said, he may not have shown up with his lawyer from Kenya, but in today's hearing, which will just be in essence for the judge to see him and say and confirm that he is who he says he is likely to have a duty lawyer already appointed to represent him for the sole purposes of today's proceeding. And then once that concludes, then they will get into the stage of him deciding who his lawyer is going to be and where that lawyer is going to come from, whether that lawyer will be his lawyers who have represented him in the cases in Kenya or elsewhere.
Yeah.
And then the prosecution will also be given a timeline within which to disclose the evidence they have against him. But at this stage, even that disclosure by the prosecution will be limited because we're in what is called the pre-trial phase of the proceedings. And this means that these proceedings are entirely for the prosecution to convince the judge that the evidence they have warrants going to trial. And the judge is not going to make a determination of whether Gisheru is guilty or not of the charges that he may be facing.
Yeah.
But the judge will just be looking and saying, okay, because of the multiplicity of evidence you have, witness testimony, documentary evidence, and everything else, I think this should go to trial. Or the judge can say, actually, it looks like you only have one or two witnesses, and even those witnesses maybe they only have hearsay evidence. So maybe this case cannot proceed to trial.
Right. And Kwamchetsi, if I bring you in here, Kwamchetsi, there are very many people who have seen this development that the lawyer has presented himself before the Hague, and there's an assumption that therefore he's cooperating with the prosecutor, and he's going there because he has struck a deal with the prosecutor. Is this the likelihood of what has happened?
Thank you. I think we would be speculating. I would go alongside a lot of what Tom Maliti has said, but I would just make two other observations. The first one is that the ICC has political capital in Kenya, and so we must look at this surrender, this voluntary surrender, also within that broader context. And I say that advisedly because if you remember in March 2018, another Article 17 suspect, Walter Osapiri Baraza, also came out publicly saying, he's now tired of living in the shadows and he wants to go to the ICC, and nothing came of it. And these people have had very high-powered attorneys, advocates, defending them right up to the Court of Appeal, so that the government of Kenya does not extradite them, and so we must look at this within the context that the government of Kenya or certain interests in Kenya are saying no, you cannot go to the ICC, and the people themselves who are wanted at the ICC seem to sort of debating and going out and saying, no, look, whatever game it is that we've been playing, we are tired of it and we are willing to go to the ICC. And Paul Gisheru, I think, exemplifies that. Having said that, I also just like to observe that Article 70, witness interference prosecutions at the ICC, are probably the Office of the Prosecutor's most successful attempts at prosecution, They have secured convictions in almost all of them. So it will be very interesting to figure out. I mean, even just doing a basic calculus to know what Paul Gisheru was thinking, and what because you see the with the other sort of crimes against humanity charges, the trial seems to be fairly lengthy and complicated in terms of even the legal arguments. Article 70 is fairly straightforward, and it's an offense against the court. I think I can only probably equate it in our jurisdictions. I can only equate it sometimes to contempt in the face of the court. So you already are starting. I think people who go in on that tend to actually start from a position of significant disadvantage, because a lot of the times, and especially in this particular case, the trial chamber, the judges have already been appraised of those alleged interferences of a matter that was already before a chamber of that court.
Speaking with veteran journalists Kwamchetsi, Makokha and Tom Maliti, discussing the ICC, Kenya's unfinished business with the International Criminal Court. We have seen lawyer Paul Gisheru has submitted himself before the court. He is due to appear before the pre-trial chamber this afternoon for just the first hearing. And this, just like Tom Maliti has explained to us, this is for the judges in the court to, first of all, just establish the identity. We've been looking for Paul Gisheru. Is this Paul Gisheru? He's come here. Do we now have him? And then from that point on, the matter proceeds. We are discussing that and many other issues.
Tom, I want to direct this question to you. In your opinion, is there any relevance whatsoever in one Mr. Gisheru presenting himself to the ICC with this as a background? One, the BBI launch, the Tangatanga Kieleweke movement, and 2022.
Thank you for that question, C.T. Muga. Of course, it is at the top of the minds of many people, especially because Gisheru had secured a favorable decision from the High Court when his arrest warrant was issued. The Kenyan government received it, and he was arrested in July 2015 on the strength of that arrest warrant. And then he proceeded to challenge it at the High Court. And the High Court eventually determined that no, this arrest warrant should not be executed. And that was about 2 years ago. So yes, this is one of the reasons why there's speculation as to why has he chosen to do this now, given everything that you've said. But I'll put it this way: he is not the first person to surrender themselves to the International Criminal Court after being pursued for several years, or after being wanted for several years on the strength of an arrest warrant issued by the court. Similarly, Congolese rebel leader Bosco Ntaganda one day crossed the border from Eastern Congo to Rwanda and showed up unexpectedly at the U.S. Embassy in Kigali and said, there is an ICC arrest warrant out for me. Here I am. Please take me to the ICC. And of course, this put people in a quandary because the U.S. is not a member state of the ICC, nor is Rwanda. Similarly, and at that time, there was no pressure for Ntaganda to present himself to the ICC. He was fighting the Congolese government in Eastern Congo, which was a stronghold of his. And so there was, on the face of it, no reason for him to surrender, but he chose to do so. And similarly, Dominic Ongwen, a former commander of the Lord's Resistance Army in northern Uganda, had been wanted by the ICC for 10 years and was was not captured and seemed to evade any form of capture. But then one day he comes out of the bush in January 2016 and presents himself to a rebel group in Central African Republic and says, I hear there's an arrest warrant out for me. Here I am. So the reasons individuals choose the timing, choose when to surrender because they're being pursued by the ICC or they have an outstanding arrest warrant against them is difficult to explain. Of course, the national circumstances in Kenya allow for a lot more speculation because Paul Gicheru's legal practice was primarily in Eldoret. Eldoret is the stronghold of the Deputy President William Ruto.
Yep.
And presumably they know each other.
Presumably.
Yes, presumably.
Yes.
But that's as far as I'll go.
Right.
Because I don't know what their relationship is. I don't know how strong it has been.
Yeah.
I don't know if it was strong in the past or it's still strong today. But I will say something else. Jean-Pierre Bemba, the Congolese politician, was tried by the International Criminal Court, and he had two cases running parallel. One was a case of crimes against humanity, and one was a case of bribery.
Yep.
And the two cases did not have anything to do with each other, in the sense that eventually Jean-Pierre Bemba was acquitted by the appeals chamber for the crimes against humanity charges, but the same appeals chamber upheld the trial chamber's decision to convict and sentence him on the bribery charges. And yet the bribery charges stemmed from the main case in that he was convicted of having bribed individuals to give testimony in his favor in the main trial. But the court distinguished between those two cases, and simply because he was convicted of bribery did not ensure his conviction in the main case.
Mr. Kwamchetsi, I want to address this to you now. Given you've heard the question I asked Tom, what is your take?
Largely with much of what Tom is saying, which is that the local circumstances will push people who are suspected or wanted by various jurisdictions to surrender. What comes to mind most recently is the surrender of Felicien Kabuga, who had been on the run for over almost 3 decades. If the local circumstances, if the circumstances change, sometimes if the political circumstances change, the ICC can look like the lesser burden. So sometimes if we actually want to perform any analysis on what has occurred, we might just want to look at our own circumstances and Paul Gicheru's circumstances and see what has changed in this environment to cause him to give up, because I think he had the protection for a while. He had the protection of the courts until I think the Court of Appeal made another decision. So why would he give that up? And of course, just to mention the other fact, which I think I've heard you express anxiety about, there's an office for the Office of the Public Counsel for the Defense, and that usually organizes how you make appearances, whether or not you have a lawyer. And if you're indigent, if you don't have money to pay for your own lawyer, the ICC generally, for purposes of fair trial rules, the ICC would try to make sure that you have a lawyer.
Right.
Yes, I think the circumstances really would help us to understand why somebody would want to surrender.
For sure, Kwamchetsi, but we're looking at Felicien Kabuga having been captured in Paris, but then we're looking at Gicheru then giving up himself and saying, okay, even if they were looking for me, here I am. I'm going to, present myself anyway. So are you saying then it's a question as to why would Gicheru give up the protection that he was then enjoying from the Kenyan courts? Is that something you see, that he was enjoying protection here on Kenyan soil? What would be the reason then? Just if again, we're going to speculate that he would give up this protection and take himself to a place where he would likely be tried. And again, the possibility of a conviction is real.
I think he weighed his options. Most likely, he weighed his options and probably believes either that he can get an acquittal, but also in the event of when suspects who are wanted on warrants surrender, sometimes that it influences courts to also consider that when passing judgment. The thing that I think informs my view is a conversation I listened to last year from the registrar of the ICC, Peter Lewis, who was explaining that in circumstances where you are trying to effect warrants of arrest, these are huge. They are huge cooperation arrangements. They are huge diplomatic undercurrents going on. So I don't know what diplomatic undercurrents were going on with regard to Gicheru, Philip Bate, and Walter Baraza. So it can be we are looking at this incident in isolation, but obviously, I mean, if you go back and check, the ICC prosecutor continues to insist that Kenya must discharge its obligations by surrendering the other suspects. So we must look at this as the ICC has been demanding the arrest and surrender of these individuals. They had the opportunity, of course, to go. They didn't go. They have chosen, this particular one has chosen to go at this time. So I guess that's the information that we have, and that's what we must analyze.
Okay, a question for you, Tom. Would anybody be quaking in their proverbial boots by this action of Gicheru at The Hague?
No.
No?
No. And for the very reason that I gave in the example of Jean-Pierre Bemba. And in Jean-Pierre Bemba's case, you had a live case going on. So Jean-Pierre Bemba's main trial was concluding as the charges of bribery were beginning, and the proceedings in the allegations of bribery were beginning. In fact, the closing statements were made like last week, and then 2 weeks later, the charges against him in relation to bribery were confirmed, and then a trial was to be opened. Now, in the circumstances we're talking about, the witnesses that Gicheru is alleged to have tampered with in one way or another, those witnesses were in the Ruto and Joshua Rapsang trial at the ICC. The status now is that for that trial to be revived, the prosecution has to come up with new evidence. So this is not a case of confirming that, for instance, if the case goes forward and Gicheru is convicted, and therefore it's found that these witnesses were bribed or there were attempts to bribe these witnesses, therefore presumably this cleans the testimony of those witnesses, and these witnesses can retestify in the case. No, that's not the case. Where the way the things stand is a trial that Ruto and Joshua Rapsang faced, the prosecution has to present new evidence. And that new evidence has to then go through the normal proceedings, which is pre-trial phase, where the judges have to be convinced of the value of that evidence, so that they can then recommend a trial.
So what you're saying, Tom, there were a couple of headlines a couple of days ago when lawyer Gicheru presented himself before The Hague, and the headlines were, here comes fresh headache for DP Ruto. Or Gicheru presents himself before The Hague, and this presents new challenges for the DP Ruto. You're saying that is not the case necessarily?
Yes, because assuming that Gicheru has the dirt on anybody, he is one witness. To date, trials about crimes against humanity at the ICC have not been based on one witness.
Okay, since we're speculating, I wanted to speculate further. Something interesting happened. The president of a country called Kosovo, a gentleman by the name of Hashim Thaçi, yes, resigned from being the president of that country and has sought to present himself to The Hague for trials, the same sort of trial that...
Crimes against humanity.
Precisely. He had been indicted by a special court in The Hague, which was which tried these issues. He's not alone. There's speakers of the assembly and other people, but he has resigned. He's president. He has resigned, and the utterances that are attributed to him is that he wants to protect the presidency.
Okay.
If we're to speculate against the background of what Kwamchetsi talked about with regards to background diplomatic negotiations and what have you, kindly speculate. What would make someone resign from his position as president so that he can go and present himself to the Hague?
Kwamchetsi, let's start with you.
I will just come back and I say I think we are comparing oranges and apples because the political context in Kosovo and the political context in Kenya is very different. But just sort of I think I hear the journalistic question you are asking, and so let me try and deal with it. A trial, one of the first things that a trial does, okay, the expectation is that it's going to deliver either an acquittal or a conviction. But one of the things that a trial will definitely deliver is that it deliver a telling of the truth. So the moment Paul Gicheru is put on trial, it is going to be possible for us to enjoy a bit of courtroom drama, for lack of a better expression. So we will actually be treated to all the allegations that the Office of the Prosecutor has against Paul Gicheru and how it links together with the owners of the case or the people who are suspected in the Ruto Sang case. Now, if you are thinking about that and thinking about our context, the ICC in Kenya is great political capital in terms of just mobilizing public sympathy. So if we actually have this trial running most of next year, and I was the deputy president, I would be smiling all the way to the bank.
Why?
Because you have this truth telling, and you are in the headlines, but you are not on trial.
You're not.
And what's the worst thing that can happen? You are going to jail Paul Gicheru for 3 years. The ICC prison is one of the best places to be. Dominic, who's been there awaiting trial, just managed to sire a child who was born last year. It's a great place. It's an excellent place to take a rest as a sabbatical. You might even come out with a book.
What you talked about 3 years. Is that the maximum sentence that one would get in the offenses under Article 17?
Tom
Kwamchetsi, surely you're saying the prisons are a good place compared to what exactly?
It's not much, eh?
The maximum sentence is 5 years.
Okay.
And a fine. I think in the case of the Jean-Pierre Bemba case, I think he was fined 300,000 euros.
Okay.
And he was given a sentence of I can't remember whether it was 1 or 3 years, because I know at appeal it was reduced.
So, you're asking,
No, I'm actually asking, yes.
The condition is better in The Hague compared to what?
Compared to what exactly? I mean, a prison is a prison.
Compared to almost anywhere on the earth. I mean, if we're going to be serious, and I think Tom can attest to this as well, Tom and Kwamchetsi, it's that the kind of menus that you're given, especially for people who were previously on, just as an example, for people who were previously on presidential status, you actually almost do live like a king, and maybe they can confirm this. If people get to the point of conviction stage,
and if you're unwell, you'll get access to the best healthcare.
The prisons from the ICC, they actually do take care of you. And maybe you can tell us about that.
I can't testify to that because I've never been in the detention
center. You've never been in
the prison. Let's be clear about that. but on a serious note, yes, if you're comparing the detention center the ICC has with Kenyan prisons or Kenyan remand centers, there is no comparison. But as CP Muga points out, once you're in custody, your freedom has been curtailed, and that's a big thing. Yes, the ICC detention center, people organize games, they play football, they cook, they share meals. But they have to follow a routine and they have to follow rules.
Yeah.
They're not free just to do anything they wish.
But just as we conclude this for our audience on KTN Home for this week, Tom, if you are unwell, and we've heard Mr. Paul Gicheru's lawyer saying the man is unwell, would he be given access to good health care while in detention?
Yes, there are medical staff at the detention center. They are required to ensure that prisoner is healthy. And if the prisoner has any particular requirements, they then address those requirements.
Right.
For instance, in the case of Dominic Ongwen, who's at the detention center, a big question has been his mental health. And he's had doctors at the detention center looking after his mental health.
Yeah.
Okay. As we conclude this, and we're looking at the Kenya's unfinished business, both of you gentlemen have talked about now. Paul Gicheru has surrendered himself. Kwamchetsi was saying, Walter Barasa, despite having some of the best lawyers in the country, at some point he got to a point where he said, I'd like to just submit myself to the court. Have we heard from or about Philip Bett, the other suspect that's being sought by the prosecutor? Kwamchetsi.
Sorry, are you asking, have we heard?
Yes, have we heard from or about?
Paul Gicheru was a very interesting character for me, at least when we were sort of following this, because he got appointed to the Procurement Appeals Tribunal as chair, which, as you know, given how much money passes through procurement, is a very, very powerful position. I think if you are reading nuances rather than like hard direct evidence, that would be an indicator that this is either somebody who has favor with the state or has because previously he wasn't one of those high flying lawyers. No one knew about him. His practice was fairly low key in Eldoret until this happened, and then of course he finds himself at the procurement board. And of course he did all these things. He actually is the only one of the three who got physically arrested. So it's very curious when you think about it that yes, there was a warrant of arrest for the three of them, but it's just he who was actually physically arrested and then released. Made sure he was going through this stuff properly in the legal way, and so I would hazard a guess and say that he is going to bring his legal training to bear in how he deals with this. So I suspect that he has looked at all the hoops that he needs to jump through, and probably has a response or a plan for each of them.
As we come to a wrap up of this, for both of you, a lot of times the ICC has been dogged with lack of evidence, lack of sufficient evidence in order to be able to take a case forward, especially with some of the cases that we see coming out of Kenya. Would this specific one be any different? Or are we seeing that they have drumloads of evidence against Mr. Gicheru at this point, and that's what they're going to use loaded up in their arsenal? Or would we likely see another case of, lack of evidence, and it seems to be on a global scale a waste of time?
No. I think we are again, as I said, we are comparing oranges and apples. This is an Article 70 witness interference or interference with the administration of justice. Mm-hmm. This is an offense or a crime that occurs in the face of the court. It's something that the court can see. Mm. If you're actually looking at convictions at the ICC, most likely many of their convictions are actually around Article 70. The more successful cases are around Article 70. The crimes against humanity cases are very lengthy, and the standards of proof are extremely high, and also the fair trial rights, fair trial rules are very, very high. So if you're looking, it's very difficult to force a comparison between these two and say, the ICC has not been obtaining convictions. It generally obtains convictions when it puts people on trial for Article 70 offenses. There was one person who was being tried alongside Bemba, I think one of his lawyers, and they were not able to link him.
And just to clarify, Paul Gicheru's arrest warrant is not he's not the only person on that arrest warrant.
Sure.
There's another individual called Philip Bett. Both of them were arrested in July 2015. Both of them challenged that arrest and the execution of the arrest warrant. the decision the High Court made was in favor of both of them. Interestingly, Philip Bett remains in Kenya, we assume. But since Philip Bett is not as well known as Paul Gicheru, it is unclear what his circumstances are and everything else. In fact, when the arrest warrant was made public, the question was, who is Philip Bett? People were able to answer the question of who is Paul Gicheru, but Philip Bett, it's unclear who is he just a farmer? What is he? So,
have you been able
Philip
to establish that? Who is he? Who is Philip Bett?
No.
Does he exist?
He does exist. I've seen him in court.
Right.
I've seen him in court. Yeah.
So as we look at now the conclusion, I mean the commencement of the proceedings now against Paul Gicheru, what will happen this afternoon? Again, just for clarity and for the benefit of our listeners and viewers, Tom, what do we expect to see this afternoon, and then what happens thereafter?
What we expect to see this afternoon is the judge will ask Paul Gicheru to identify himself, will confirm who he is, then they will read the charges against him to inform him of what he's alleged to have, what he's accused of. There will be a duty lawyer beside him, most probably. And then the judge will then will ask whether there's anything of immediate concern that Gicheru needs to address, or the prosecution. It is possible that the judge may announce a possible date for confirmation of charges hearing.
Yep.
And then it will be that. So I think that's where things will stand. Then going forward, then now processes will start. If Paul Gicheru decides that the duty lawyer is not the person he wants to represent him, then he will be given a choice of he'll be given the opportunity to choose a lawyer. So
he can actually even play a dance with them and just keep rejecting the lawyer that he's given.
No. Those kind of delay tactics that may be common elsewhere at the ICC, they will not be tolerated. He will be given time, as in maybe a week or so, because he's in detention, so he can't argue that he doesn't have the time.
Okay.
And very quickly the registry will make arrangements for him if that's what is needed. To provide legal aid to make sure that he's able to hire a lawyer and get a team and so on.
Asante sana. Tom Maliti, veteran journalist and author, thank you very much for your insights this morning, as well as Kwamchetsi Makokha, journalist. Asanteni sana and have a good day, gentlemen.
Thank you for having me and have a good weekend.
Thank you very much.